Self-test. What are the civil rights laws that affect funded faith-based organizations? In this training segment, we provide self-test scenarios to see how well you understand a faith-based organization's right to receive federal financial assistance and that organization's related obligations when providing services and benefits. Here is background for the scenarios that follow. People with the Mission of Princeton, a faith-based organization, provides a range of social services to young people. In fiscal year 2012, People with a Mission received funding under the Juvenile Justice and Delinquency Prevention Act and the Victims of Crime Act to operate an after-school program for teenage victims of gang violence. The first scenario, hiring at People with a Mission. The Reverend Johnson, pastor of Princeton Assembly, is the founder of People with a Mission. In hiring a coordinator for the after-school program, he wanted someone who shared his values. He asked Sue Williams, a student at a nearby seminary where he teaches, to apply for the job. She submitted her application and was hired. Does her hiring pose any potential civil rights issues? Here's the answer to the first scenario. It might appear that the hiring decision the pastor made in looking for someone who shared his religious views might be problematic. However, DOJ's current position is that a faith-based organization can base its hiring practices on the religion or religious beliefs of an individual if it can demonstrate two things. First, the program for which it seeks or receives federal funding is an exercise of religion. Second, that requiring it to either forego its religious preference in hiring or else forego the federal funding would substantially burden that exercise of religion. The final point is that the Justice Department, as the funding entity, has not provided a sufficient justification to prevent the organization from making a religious-based hiring decision. Specifically, it is unable to show that applying the non-discrimination provision in this instance furthers a compelling government interest and is the least restrictive means of furthering this interest. This exemption is based on DOJ's interpretation of the Religious Freedom Restoration Act, which prohibits the government from unfairly burdening the practice of religion. For a faith-based organization to receive this exemption, it should file a certificate of exemption form with the agency that provides it with federal funding. In this case, those agencies would be the Office of Juvenile Justice and Delinquency Prevention and the Office for Victims of Crime. It is important to remember, however, that this exemption has no impact on the faith-based organization's obligation not to discriminate against beneficiaries and potential beneficiaries based on religion or religious beliefs. The second scenario involves an invitation to a church service. Princeton Assembly has a long-established custom of holding a community supper every Wednesday evening, preceded by a short service in the sanctuary. According to a high school guidance counselor, at the end of each session of the after-school program, the pastor invites the young people to stay for the devotional service and meal. She said a few would stay, but most would leave. Are there any potential civil rights issues? Here is the answer to the second scenario. A possible violation might be the mixture of the community supper, the devotional service, and the after-school program. Because the events, the after-school program, the community supper, and the devotional, are separate in time, the arrangement might be acceptable. It would be important, however, to find out how voluntary the pastor makes the invitation. For instance, do the young people feel pressured to attend? Generally, faith-based organizations should consider the age of the children it serves, because children may have a harder time saying no to a strong suggestion from someone in leadership. The best practice would be to ask for parental consent before allowing minors to participate in explicitly religious activities that are separate from the federally funded program. The third scenario deals with a participant's objection to religious content. The guidance counselor referred Bart Bennett, a high school student, to to people with a mission. After his first session of Sue Williams's after-school group, Bart reported the following to the counselor. "I just didn't feel comfortable. There were crosses everywhere. They kept talking about Jesus, saying how much faith saves you, and then I felt pressured to go to church." Are there any potential civil rights issues? Here's the answer to the third scenario. A possible problem is that Bart says he felt pressured to go to church, and they kept talking about Jesus. In thinking about this issue, it would be helpful to understand who pressured him to go to church and who kept talking about Jesus. If other students in the peer group talked about their beliefs, that is not problematic because they, of course, have their own First Amendment rights. But if the group leader made those statements, that would be an explicitly religious activity, proselytization, that cannot occur at the same time and in the same location as the federally funded program. It would be helpful to know if this discussion occurred during the program and whether students were allowed to participate voluntarily. Finally, it is acceptable under the Equal Treatment Regulations for a faith-based organization to keep its religious symbols in the area where it operates the federally funded program. Religious icons or symbols, such as crosses, in and of themselves, are not problematic. The fourth scenario involves the responsibility of a funded faith-based organization to refer a beneficiary to an alternative service provider. Bart Bennett told the Reverend Johnson that he would not attend any more after-school sessions at People with a Mission, as he was uncomfortable being in a church. The pastor told Bart to take a few days to think about it. Did the Reverend Johnson respond appropriately to Bart? Here is the answer to the fourth scenario. The pastor probably responded appropriately when he asked Bart to take a few days to think about staying in the program. Under Executive Order 13559, the pastor should have, however, also given Bart a referral to an alternative provider within a reasonable period of time. People with a Mission should have referral policies and procedures to ensure that beneficiaries who object to its religious character can access services from other sources. The fifth scenario deals with the tax status of funded faith-based organizations. People with a Mission has no form on file with the IRS recognizing its tax-exempt status under Section 501c3 of the Internal Revenue Code. Is this a problem? This typically is not a problem unless the program is funded under the Juvenile Justice and Delinquency Prevention Act. Here, People with a Mission is funded by a grant under that act. As a result, it would need to have Section 501c3 status with the Internal Revenue Service. This concludes the self-test on the training segment. What are the civil rights laws that affect funded faith-based organizations?